What happens if my spouse or significant other fails to respond to a petition? Hi, my name is Heath Davis, and I'm an attorney here in Tulsa, Oklahoma. We often get the question is, if I engage an attorney and we file a petition for dissolution of marriage or a petition of paternity, what happens after that? Typically, when we first file that document, we also ask the court for what is called a summons. A summons is the documentation that effectively tells the court that that person has been served pursuant to the statute. That summons is then filed with the court and engages a process of 20 days in which the other party has to respond to that initial petition. Oftentimes, there are parties who refuse to engage in the judicial process. They don't want to get involved for various reasons. They may not want a divorce. They may not want you to have access to the minor children. However, in Oklahoma, we are fortunate enough that they cannot simply stonewall that process. So if a party fails to respond within that 20 days, you have the option to file what we call a motion for default judgment. A motion for default judgment it notifies the other party that, hey, we are seeking this default judgment. You have failed to cooperate in the judicial proceedings. And the court then has the ability to grant you that default judgment, which authorizes the relief that you had requested in the petition. So if one party is unnecessarily delaying or they don't want to engage, there are remedies out there that we can find some closure for your case.